What? He just turned around and walked out. Why is he doing that? He's learning that stuff from Ron Brown. He just that Bernstein.
No, it's not. It's actually instruments.
Why? Why'd you get Max first? Because he makes me. He was anybody putting you in this conversation? Because see, I thought he was late. Someone was here. He was here. Why are we doing Max?
Because J comes before M in the alphabet.
Math is
Those are the
side Judge.
Why are you talking? What?
Math is on my side, Judge.
Sam never makes me wait. Mac is always making me wait. Gotta go see Judge Perry. Just wait, Judge. It's okay. He always does that. Who do you have?
That's Mr. Johnson. Belongs to Mr. Mack.
Yes, sir. That's exactly right, Jimmy.
This is killing me.
Yeah.
You can? Please.
Oh wow.
No, I'm not talking to you.
This is becoming really obvious.
Is it? I don't know what's becoming. Sam was here first.
Good for Sam.
I was here.
That's right. He was here. He was waiting patiently. He doesn't make me wait in the morning because he's got to go see Judge Perry. It's like with Mac, he was what?
Monday.
I know, but you're not here the rest of the week, are you? Let's hope not. Anyway, court does call the case and the people persist. I'm Matthew McIntyre.
Good afternoon, Your Honor. Sam Bernstein with on behalf of Mr. McIntyre.
Morning. Your name?
Amazio McIntyre.
Thank you.
Asking the court to please set this for a final settlement conference.
We have want those dates and would people be ready?
That's fine.
I think we'll be ready on the 5th. My understanding is that there's another case set for exam tomorrow involving the same defendant and the same victim. So we'll know by tomorrow whether that victim is cooperative regardless of when the court.
Got it. Jury final settlement conference will be set June 2026 at 9 a.m. Jury selection, if necessary, will be June 8th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor. We wish Mr. Mack the best of luck in his case after us.
Yes, sir. And Mr. Bernstein, I appreciate your patience. Take care. You can bring the other guy. Take your time.
Like I said, Judge, it's only Monday.
It's only Monday. That's right. I also don't think that's like the beginning of my week. I don't think I should call Mr. Mack's case at all. I just shouldn't start a week out that way. And that's my thought.
Judge, you're still on my Christmas list. I want you to know.
Yeah, I get the Max package. I got to get the bomb squad and everything. It's court calls the case, people versus Anthony Johnson.
Yeah,
Good afternoon, Judge. You go to Shane Mack. Appearing with the behalf of Mr. Anthony Johnson, who is approaching us at the podium. Please state your name for the record, sir.
Anthony Johnson.
Sorry about the wage.
Wow. Judge, after having discussion with the prosecutor, we would just like to schedule this matter for a final settlement conference.
All right. With the
requesting the August date on this one. This case was arraigned, I believe, on the 23rd of last month. Not been able to have contact with the victim to see what her position is yet. So I just asked for the additional time. I know that Mr. Johnson is in custody and that's quite a ways out. I believe that's what was holding this case as well as parole. And I think that's this case. I am wondering if it might make more sense
just set it
to adjourn this, maybe 2 weeks, give people time to become, at that point we could set for a bench trial, maybe in advance of the August final settlement conference date, but I'll leave that to defense counsel and the court's decision.
Well, I would, so our dates, our August dates are what?
For bench trial,
No, for jury,
August 17th.
7th and 10th.
Yes.
Okay, so if you, I set it for jury, I don't get dates until August 7th and 10th. Which would mean basically June, July before we get to them. It might make more sense. It wouldn't delay you setting a jury. I'm not going to ask that you make a decision on bench trial, to just adjourn this out, let Mr. Cook figure out what's going on that side of the case. And then if we have to come back, we can set it. It'd be the same dates that we would set today.
Sure, Your Honor. So, so maybe set this up, adjourn pre-trial for a couple of weeks, basically, is what you're saying?
Yeah, so that's what I would be looking.
Okay.
That make contact, figure out what's going on with his case, and then do
Can do it.
because he's got a parole hold at this point in this case. That's it, right?
That's true.
So, okay.
That's true. But at the appropriate time, I'd like to address the bond issue minus the parole hold issue, if that's resolved in front of Your Honor at the appropriate time.
Okay, we can do that. What's my next? Well, what do we have 2 weeks out about?
June 15th.
June 15th? Okay. Then let me adjourn the pretrial in this matter to June 15th, 2026, 1 p.m. or actually 12 p.m. All right. That's the bond.
Your Honor, as the court is well aware, my client is currently detained on a parole hold. I have tried to reach out twice to the parole officer with success. Have you been in touch with the parole officer?
No.
So we're not sure what the status of that is, Judge. If that parole hold stays, well, obviously he's not going anywhere.
Right.
For some parole hold, in fact, we would ask you to please set a reasonable bond for Mr. Johnson. He's not a flight risk. He has reason to be accounted, because if he violates, then he's got an excellent chance of being returned to the penitentiary, which is what he does not want to do. So I would ask for consideration of a reasonable bond, Your Honor.
I don't need a response to the appeal. I don't think I'm going to change his bond. If for whatever reason you figure out something on the parole hold, then certainly I'll take a look at it. But right now, I don't. All I know is there's a hold. He hasn't been in touch with his parole officer. Nobody knows. So I'll just leave it where it is at this point.
All right.
All right.
All right, Your Honor.
Thank you.
Okay, I'll come down to the jail to see Mr. Johnson.
Oh,
Okay, all right, thank you.
bond was. Me? I appreciate it, Mr. Mack.
Appreciate you, Judge.
That was it. All right. What? He just turned around and walked out. Why is he doing that? He's learning that stuff from Ron Brown. He just.
Yeah, Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Boggs.
Sir, your name? Brandon Boggs. Thank you, sir.
Your Honor, at this time, we'd be requesting to set both of these matters for final settlement conferences. After a conversation with Mr. Cook, we believe we could have these matters resolved on Friday if we can get this put on the Friday final settlement conference docket.
And that's correct, Your Honor. No objection.
The June 5th,
Yes.
Yes.
because I don't have enough to do. Jury final settlement conference, June 5th, 2026. At 9 a.m. Jury selection, if necessary, June 8th, 2026 at 8:30. Both of those proceedings are in person. Bond will continue. All right.
Thank you, Your Honor. See you Friday.
Courthouse days, people versus Jawan Campbell.
Good afternoon, Your Honor. Raymond Cook for the people.
Oh,
Good afternoon, Your Honor. Ron Brown appearing on behalf of Mr. Campbell.
days on Campbell.
Your Honor, we'd ask the court to set this for final settlement. We are hopeful.
Friday.
we're hopeful to have a resolution favorable.
No objection to that. Your Honor.
Cook needs to get an objection. Anyway, jury final settlement conference, where we set June 5th, 2026, 9 a.m. Jury selection.
1 p.m. I was gonna say 1 p.m. possible. I got a job. I was asking.
It's set at 9.
Hope that you won't have to come back to court after Friday.
That's fine.
So,
We're hopeful.
are you going to be able to work around it, or?
Yeah, I'm working around. You said it. I'm doing it.
Well, no, I got you, but I don't want you losing your job either. All right.
We gonna make it happen. 1
Pardon?
o'clock will be preferable. But
What?
I said 1 p.m. will be preferable, but 9 a.m. if I got to, I make it happen.
If I liked this attorney, I'd do it.
Well, get up here, Nick.
No, no. Sir, sir, I can't do that. They're all set at 9. Okay. What we can try to do is get you in and out as quick as we can now. All right.
Thank you.
Give it. Jury final settlement conference, June 5th, 2026, 9 a.m. Jury selection, if necessary, 8th, 2026 at 8:30.
Thank you.
Both of those proceedings are in person. Thank you. Ryan was about to bail as quick as court calls the case, people versus Cecil Levine.
Definitely trying to read.
And Assistant Public Defendant Nicholas Butkovich on behalf of Mr. Levine, who is approaching.
Oh,
I didn't run away this time, Your Honor.
no, I know. I saw very good.
Can you please state your name for the record?
Cecil Levine. Thank you. What are we doing?
At this time, Your Honor, I'll be asking to set this matter for final settlement conference on this Friday because we really need the matters resolved.
On this Friday?
Yes, on the 5th.
Jury final. I'm getting there's a theme. Jury final settlement conference, June 5th, 2026, 9 a.m. Jury selection, sir, if necessary, will be June 8th, 2026 at 8:30. Both of those proceedings are in person. Thank you, sir. Court does call the case of the people versus Jackson Sturtevant.
Good afternoon, Your Honor. Reading for the people.
Ron Bonaparte on behalf of Mr. Sturtevant. I believe he's appearing by Zoom.
Yes, yes. Thank you, sir. What are we doing?
I'd ask that it for trial on Friday.
Trial or for jury final settlement?
Final settlement. Misspoke here.
Jury final settlement conference will be June 5th, 2026 at 9 a.m. Jury selection, June 8th, 2026 at 8:30. Both of those proceedings, Mr. Sturtevant, are in person.
Okay.
Thank
All
you.
right.
Your Honor.
Thank you.
Thank
It's like when you're dealing with your kids, and all of a sudden they're around, something's all happening, but it's all happening. You're seeing a pattern and you know they're up to something.
Nick started.
That's how, no, I'm just saying.
It's all Nick's fault.
It's all Nick's fault. Court calls the case, people versus William Fridge. Where is he?
Rich president?
I do not have him. No, he is not.
Teresa Claire on behalf of the safety driver, Mr. Jake Cruz is scheduled for the court for hearing. I which today. Because I did have a conversation with him about not invited by the payment plan that was set by the court. Given that Mr. Cruz is not here, I guess probation at this time is going to ask the court to. Open the hearing.
You know, he was having issues, but he could have come, well, was at one point, but he could have come before the court to kind of explain some of that. I'll issue a bench warrant for defendant's failure to appear. Bond will be set in the amount of $7,500. I'll give a 10% privilege on that. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case People versus Caitlin Morgan.
Public Defendant Nick Bukovich on behalf of Ms. Morgan.
Hi, Miss Morgan.
Hello.
In here. I don't know how to
Okay.
get rid of this off of my screen. Sorry.
Background's fine, Ms. Morgan.
Yeah, it's okay.
Sorry.
It's like
Hi.
you're in a fish tank. All right. It's all right.
Sorry about that.
All right, what are we doing?
Your Honor, this morning was for the court for a hearing. At this time, Ms. Morgan's compliance, accepting, her balance, she does $1,000. She's made no payments. The court did previously give her a reduction due to her graduation from college of $785. I do know that Ms. Morgan, did have some surgeries that she had to have due to, a severe injury from her arm, and that she was doing therapy with that. However, at this time, permission would ask, that Ms. Morgan be put on a payment plan of $50 a month beginning on July 1st. That way she can be on track to patient by the end. Continue all other terms as previously ordered, with the next review hearing being set September 14, 2026 at 1 p.m.
Yes. Unfortunately, I was unable to speak with Ms. Morgan. Ms. Morgan, last week when we were trying to talk, we were having phone issues. We couldn't hear each other. So my question for you would be, would you be able to make a $50 payment by July 1st?
I might be able to. I don't want to say for sure, but I could try my best. If I can't make the $50 payment, I will get as close as I can to 50 if that's okay. Can you hear me?
Yeah, are you not working or what's going on?
No, I'm actually not working right now. I'm actually waiting. I actually got some paperwork in the mail. I'm actually trying to get approved for disability at the moment, and they actually got a court date for me to go in front of a few judges because I had got denied. So I have a lawyer that's helping me out with that. And then I also have a civil suit for the person that hit me in my car accident, and that's going on too, but what's going on with my arm, it's not fully functioning yet, so I can't really work yet.
Okay, so let me ask you this. When are your court dates for your disability?
So I sent in some paperwork. I had to sign release of records, and I had to sign to agree to get the court date. So I'm waiting for the court date in the mail. I should be getting it any day this week.
And let's do this. What I'm gonna do is I'm gonna order that the defendant pay $50 by July 1st, 2026, and then $50 per month thereafter. Get as close as you can and keep in touch with Miss Valera. You understand that?
Yes, sir. Yes, Your Honor.
I'll continue all other terms as previously ordered. I'll set our next review date, September 14th, 2026, 1 p.m.
Thank you.
All right. You're welcome.
Have a great day, you guys.
You do the same.
Thank you.
Thank you.
Court calls the case, People versus Travis Oliver.
Public Defendant Nicholas Bukovich on behalf of Mr. Oliver, appearing via Zoom.
Oh, there he is. Your name?
Travis Oliver.
Teresa Claire, I'm making probation. Your Honor, Mr. Oliver is before the court for a final review hearing on a prosecutor deferred sentence. So the court was aware Mr. Oliver did have a case. That case is not set for a pretrial until mid-July on the felony debt. Mr. Oliver did face a sanction due to his behavior due to that case where he was ordered to and completed the domestic violence program. And he has finished all other terms in this case. he has been on probation under this deferred for a period of 1 year. Given all of the circumstances, at this time, probation is asking the court to dismiss the case pursuant to the prosecutor deferred and discharge him from probation with improvement. He has made that $380 outstanding.
Oh, he paid it?
Yeah, you paid it today.
Paid it today?
Yes,
I
sir.
didn't think he would. No, I'm just messing. I thought he'd be stringing me out, trying to get me to like cut some, do something.
Oh, no.
That's been my dealings with Oliver for the past year. No, I'm just messing with you. All right. You have any objection, Mr.
No objection, Your Honor.
All right. It having been paid, this case is dismissed pursuant to the prosecutor's deferred. I'll discharge the defendant from probation with improvement. Mr. Oliver, good luck to you, sir.
Thank you, sir.
All right. Take care.
You too.
Your Honor.
Court calls the case, People versus Roman Williams.
Ron Brown King on behalf of Mr.
Tracy Claire on behalf of probation, Your Honor, Mr. Williams was scheduled to go to court for hearing on 2 cases. Mr. Williams was set with a payment plan to be making consistent payments with the court. Mr. Williams is from the payment plan of effect. Given that the date of appearance present today's hearing, probation will that all conditions are continued as previously ordered. With the next hearing being set August 3rd, 2026 at 1 p.m.
No objection.
So order. At all? Really?
Yeah.
No drama? Okay.
Yes.
The day's not over with, that's true. All right. 14A stands adjourned.
Thank you. Good afternoon.
What started as an ordinary court docket quickly turned into a mix of humor, tough decisions, and second chances as defendants stood before the judge hoping for favorable outcomes. The hearing opened with a light-hearted exchange between attorneys and the judge, who joked about lawyers keeping him waiting and playfully teased them about their cases. But once the proceedings got underway, the focus quickly shifted to serious criminal matters, including assault cases, probation reviews, and defendants facing possible trial dates. One of the day's most important moments involved a defendant who was being held on a parole hold while awaiting resolution of a criminal case. Defense counsel argued for a reasonable bond, but the judge declined to make changes until more information became available, emphasizing the need to fully understand the parole situation before taking action. Later, the courtroom saw a stark reminder of the consequences of missing court. When one defendant failed to appear for a scheduled hearing, the judge immediately issued a bench warrant and set bond at $7,500, making it clear that attendance in court is not optional. The mood shifted again when a young woman recovering from serious injuries explained that she was unable to work while pursuing disability benefits. Rather than immediately penalizing her for financial struggles, the judge listened carefully and created a manageable payment plan, encouraging her to stay in contact with probation officials. The hearing ended on a positive note when another defendant successfully completed the requirements of a deferred prosecution agreement. After paying his remaining balance and finishing the court-ordered conditions, the judge dismissed the case and discharged him from probation, offering a final message of encouragement as he moved forward with his life. By the end of the day, the courtroom delivered a powerful lesson. Show up, follow the rules, and take responsibility, and the court may be willing to give you a second chance.